I'm Jonathan Wardle. I'm here on behalf of plaintiff Janine plaintiff appellant Janine Halterman-Scott. We're asking this court to reverse the trial court's grant of summary judgment and to remand the case because the trial court did not consider plaintiff's evidence against summary judgment. I would like to reserve 4 minutes.
Okay, thank you.
Rebuttal. Thank you, Judge. I sometimes forget. I want to start, before I dig into our main arguments, just with responding to a part of TSCPA's brief that it's on page 15 of their brief that says that we tried to bolster our argument by omitting part of the trial court's decision in one of her quotes. I just want to clear that up. That the quoted language with the ellipsis was in a parenthetical in a string cite on page 16 of our brief. The string cite was there just to say, or to show the many times the trial court referred to this supposed admission and relied on that. The omitted material was, it doesn't change the fact that the court also referred to this supposed admission again. We're not trying to mislead the court in any way, and I had the full quote on page 9. So I just want to clear that up in case the court has any concern that we were trying to mislead it, that there's no intent there. Ms. Halterman-Scott presented the trial court with evidence to withstand the motion for summary judgment. The issue before the trial court, was whether TSCPA had constructive notice of the hole in the ground that caused Ms. Halterman-Scott to fall and be injured. In other words, whether notice should be imputed, that's what constructive notice is, whether notice should be imputed to TSCPA because it could have discovered the hole by proper diligence.
Counsel, you say that that she presented to the trial court evidence. Where was that evidence presented? I mean, there's admissions in response to the other side's statement of undisputed facts. She doesn't have her own statement of undisputed facts. Where are these facts presented to the trial court that would show, and you're not asserting actual notice, right? So we're talking constructive notice in this case. Where are the facts presented to the trial court?
When Ms. Halterman-Scott responded to the motion for summary judgment and the statement of undisputed facts, she responded with a memorandum of law. Simultaneously filed was a response to the statement of undisputed material facts. Simultaneously filed was a set of exhibits, 5 exhibits. They're all filed at the same time. The 5 exhibits numbered 1 through 5. Some of them were referred to in her brief. Some of them, and the trial court seemed to think that she didn't, but some of those were referred to in the response to the statement of undisputed material facts. And that is proper. You can present evidence in response, and that's what she did. The issue here is, technically, if she wanted to present additional facts, she probably, well, the rule requires you can provide that in part of the response. She didn't do that. She did, however, state those facts clearly in her response brief. She cited to exactly where, even to the page number of the exhibits.
If the trial judge, so the trial judge has the statement of undisputed material facts, and I understand your argument that one of them is just an admission of there's no actual notice. In terms of showing constructive notice in this case, isn't the trial judge well within his right to say there's nothing in the statement of undisputed material facts, there's no denial, there's no statement from her, to essentially say I'm not going to go looking through the exhibits when she's telling, she hasn't given me any facts that show constructive notice. And is it really error by the trial judge not to go on that sort of fishing expedition looking to see what he can find?
I would submit that it is, Judge, yes. And the reason I say that is because, first of all, it's not a fishing expedition. She cited exactly in her brief where. So the judge didn't have to go pulling through. And if the judge did, it's a whopping 10 pages. But
did she even use the words constructive notice in her brief?
She did not.
So, and she doesn't say it's constructive notice. There's no cite to an exhibit saying this is what would show constructive notice. So the trial judge is supposed to look at the exhibit, figure out that the basis of the constructive notice is something in the exhibits, and that's how they get there. And you're pushing the trial judge pretty far down the road in terms of having the trial judge engage in error, it seems.
Your Honor, my response to that would be, first of all, she did not use the words constructive notice. She does not have to. She stated the law correctly. And the law is if through proper diligence they would have discovered the hole. That was her argument. She didn't use the words constructive notice, but she certainly said what is required.
Is there anywhere in the expert's report where they indicate when the hole developed, or give any facts that would say when this hole appeared, or, I mean, not first appeared, but some sense of how long it had been there?
The expert report was provided not to say how long the hole was there, but to say that you have a duty to inspect. The TSCPA has a duty to inspect. That was the point of the expert report.
Isn't that her problem, though? Doesn't she have to provide some evidence that could provide a basis for the trial judge figuring out how long the hole has been there in order to have constructive notice? I mean, don't we have to have some factual basis that they could have had long enough to figure this out, or should have figured it out?
She does, Your Honor, and she did present that evidence. The evidence she presented, first of all, the expert report, as I was saying, it was primarily to say they had a duty to inspect. As part of that, it discussed the size of the hole and the fact that it was hidden by grass. It was based on statements, photographs, and the report said plural photographs, and all the discovery responses. Not all of that was presented to the trial court, but it was an expert report. She also presented a photograph, and that's the supplemental volume 3 of the record, is a color photograph that shows the hole. It shows how large it is. It shows that it had been there long enough to have grass grow over it again and get long enough to be cut, because it's cut even with the other grass. That, I would suggest, is sufficient, at least to withstand a motion for summary judgment, by which a reasonable jury could look at that and say, you know what, this was here long enough. They cut the grass. They should have discovered the hole and done something about it. It's like the Williams case that I cited in my brief.
Is there anywhere where that argument is made? And I understand your contention now on appeal. It's interesting in terms of thinking about the grass cutting height, how long it takes for grass to grow up to an equivalent height at that level of depth, suggesting a time period. But is there anywhere that statement is actually made to the trial court judge here that, Judge, you got to look at this photograph here and see that the grass is actually at the same level? And if you think about 6 feet deep that's 6 inches deep.
6 inches, yes, you're right. 6 feet would be
6
pretty
feet
nice.
Would be very big. 6 inches deep hole. It's going to take some time to grow to that. Interesting argument, but is there anywhere that's actually stated to the trial judge that's, Judge, we do have evidence of constructive notice, or she doesn't say constructive notice, we do have evidence that meets the standard. Look at the photograph. Is that ever stated to the trial judge here?
A significant portion of the response brief is dedicated to the McKinney opinion. I think it's McKinney opinion. That opinion, the entire thing, and it talks about it in the brief, is they mowed the lawn, and the defect was in that lawn long enough for it to have been mowed over, so there was sufficient evidence of constructive notice. That was their argument in their brief. They relied heavily on that.
Did they ever state that, though, as the facts of this case? And I understand they're citing a case involving a football field with grass being cut, but is there a statement that they cut the grass here regularly and the height was of equivalent height in terms of over this hole, so therefore the grass must have had a significant time period to grow? And is there any assertion to that effect?
I don't know if that was said at the argument or not, because we don't have the transcript of the argument.
Is it anywhere in the briefing?
What we have in the brief is reference to the hole, the size of the hole, reference to the fact that it had been there, reference the argument that it had been there long enough to have been discovered, and then a reference to a brief, not a reference, a discussion of an opinion with that exact same argument. I would submit that it was error for the trial court to refuse to consider her evidence, and that's what the trial court did. I know appellant's brief says, the trial court just said the evidence wasn't enough. That's not what the trial court said. I'll read you what the trial court actually said.
Let me ask you, so it's a 5-inch depression in the grass, and you don't know how often they mowed.
I do not know.
You don't know what kind of mower they use. Is that right?
Do not.
Whether they use the push mower, a commercial mower that cuts a path.
I don't know if any of this was in the
6
discovery.
feet wide.
Correct.
With wheels that are an inch wide. What is the proof that by cutting the grass they would be aware of the depression that's only 5 inches wide?
Well, again, if you look at
constructed notice of that.
If you look at the photo, you will see that it is an obvious depression. And if you look at the photo, you will see that it has obviously been mowed over. Our argument is whether or not the jury has to accept it, it is enough to get to the jury, for the jury to decide, is this sufficient evidence? And that's what this should be. It should be a jury decision, not the trial court saying, no, you don't get it, you don't get in the door. And I would point out again The trial court didn't even consider the evidence. I would like to briefly address the Brennan case cited by TSCPA in its brief. That case is interesting because the argument in that case, the issue in that case on appeal was that the plaintiff had not filed any response to the statement of undisputed material facts. But the plaintiff did file their own statement of additional material facts. It wasn't enough to address all of those other questions. What's interesting about that case is they filed that statement of additional material facts. It did not cite to the record. Defendant objected, said, hey, this technically does not comply, which is what the trial court said in our case. This technically does not comply with Rule 56.03. The trial court considered the evidence anyway and then said, but this isn't enough to overcome the failure to respond. In our case, the trial court said, and maybe I'll have time to address it in rebuttal and quote, but the trial court said very clearly, she didn't do this correctly, and so I'm not considering it. Didn't say the words, I'm not considering it. What it said is, she didn't present the evidence correctly, and so there is no evidence of. She never said, this evidence wouldn't be enough. The trial court never addressed the evidence other than in one footnote, discounting the credibility of the expert report, even though it was never objected to. I'll leave it there and save the remainder for rebuttal unless there's another question.
No questions. Thank you.
Thank you.
Good morning, Your Honors. I am Anthony Berry for the defendant, Tennessee Society of CPAs, and I am here to, do I need to press a button on this? Oh, there it goes. And I'm here to argue in favor of upholding the granting of the motion for summary judgment. Now, the plaintiff's counsel has made a big deal about what he had in his brief, saying that he was arguing for constructive notice, but I'd like to direct the court to page 182 of the record, which contains a quote, which contains a page from his brief in opposition to my motion for summary judgment. He says, the issue in this case is not whether defendant had notice of the dangerous condition, in this case the whole, but rather the lack of due diligence to discover, maintain, and correct the dangerous condition. So I think it is incorrect to say that they were arguing for notice when they outright say in their brief that the issue is not notice. They tried to make the issue something else, and now they are trying to rework their argument into an argument for notice. The issue we're here to discuss today is, did Judge Woodruff commit an error of law in granting the motion for summary judgment? I think it is clear from the record that he did not. The basis for his opinion was cited with those ellipses that were discussed a moment ago on page 16 of the plaintiff's brief on appeal, and the actual text of the opinion was, it is undisputed that Mrs. Halterman-Scott has no evidence regarding the hole's origin or what caused it, revealing how long the hole was present in the ground at the time of her accident, that anyone else walked into the hole before she did, or that the society was ever put on notice regarding the presence of the hole. Now, these additional items, these three that the court mentions, are very important to the court's decision, because what we're here to discuss today is constructive notice, and the standard for constructive notice is if the condition lasted long enough that the defendant should have been aware of it through reasonable diligence. In their response to my statement of undisputed...
Does reasonable diligence include searching your lawn for holes?
I do not know, Your Honor. I would imagine if you have a business that you would probably want to search it for holes, but if you happen to find one, then you would want to do something about it.
Okay.
Yes, Your Honor. In their response to my statement of undisputed facts, which is found on page 185 through 187 of Part 2 of the record, I said, plaintiff has no evidence that defendant was ever put on notice regarding the presence of the hole, and they responded with, admit.
Counsel, with regard to put on notice, and opposing counsel makes the argument that that's really referring to actual notice rather than constructive notice, that the put on portion of it and their admission there is designed to, that they weren't actually aware of it, they concede that, but not a concession. What makes that a concession of constructive notice, or is that just a concession of actual notice?
Well, let's say for the sake of argument that it is only a concession for actual notice. There are three other admissions they made that the court cited. Plaintiff has no evidence regarding the hole's origin or what caused it. Answer, admit. Plaintiff has no evidence revealing how long the hole was present in the ground at the time of her accident. Answer, admit. plaintiff has no evidence that anyone else walked into the hole before she did. Answer, admit. The court cites all three of these in addition to the statement that she has no evidence that the society was ever put on notice of the hole. So what we have here is both admissions regarding constructive notice and admissions regarding actual notice. Because the standard, again, requires that the hole in the ground be present long enough my client should have found it. Well, she admits she has no evidence of how long it was there. What she wants the court to do today is to look at her photograph, and in her brief she mentioned her expert report, and find evidence that contradicts her own admissions. Rule 56 is very clear. In pertinent part, it says any party opposing the motion for summary judgment must, no later than 5 days before the hearing, serve and file a response to each fact set forth by the movement, either agreeing that the fact is undisputed or agreeing that the fact is undisputed for purposes of ruling on the motion for summary judgment, or demonstrating that the fact is disputed. Now, this was the part of their response where they were supposed to say, this fact is undisputed. Now, he mentions the Brennan case where they talk about a party who did not file a response at all. Filing a response and admitting you have no evidence is more harmful than not filing a response at all, because that leaves the field blank. They stated outright they don't know how long this hole was there. They stated outright, we have no evidence as to how long the hole was there. Today they're saying their photograph shows how long the hole was there, or at least it creates an issue. They should have said that in their Rule 56 statement instead of admitting that they don't have that. Judge Woodruff committed no error of law by holding them to the effect of their own admissions. And to rule otherwise would have been to destroy Rule 56.
Counsel, is there any statement in the briefing before the trial court that references the photograph and develops an argument related to the height of the grass and how it's cut? Or is the argument essentially something that the trial judge would have had to come up with on his own in terms of looking at the photograph and saying, wow, that's the same height. It must have taken some time period for that grass to grow. Is there any argument in the briefing that actually specifically ties to this issue of cutting the grass in the photo?
I do not have their brief memorized, but I believe that their argument focused mostly on that the hole should have been found during regular mowing. But I'm sure plaintiff could assert what is in his brief better than I can, because I do not have his brief memorized. But again, they said that they didn't have any. And to hold them accountable to the consequences of their own admissions, I don't think would constitute an error of law. It's essentially a stipulation. If they say that the fact is undisputed, or even undisputed for purposes of the motion for summary judgment, they cannot later come around and say, oh, wait a minute, we didn't mean that. We actually did have evidence of constructive notice or evidence of notice of any sort. Whoops, we didn't mean to admit that. Well, it's too late. They admitted to it. And now they're stuck with that, and the court held, you do not have evidence of notice. Therefore, since evidence of notice is an essential element of your case, and you can't prove it, summary judgment is warranted. I know I have quite a bit of time left, but if you have any questions.
What was the size of the lawn at this location?
The size of the lawn?
Yes.
I'm afraid I do not know how large the lawn was. I'm sorry, Your Honor, I do not know that.
Okay.
No other questions?
Thank you, Your Honor.
Thank you.
With respect to that last question, and this is in the record and you'll see it, this is where she fell, right next to a sidewalk. And the circled area is the hole. You all will see that in the record. With respect to what's in the brief does not spell out as clearly as I have the length of the grass, et cetera, but it does refer to the expert report, where the expert report cites TSCPA's own document on things and says that their own handbook requires regular inspection of the property. So they had that duty for regular inspection. I realize it's not as clear as I would like it to be, but I think it's enough to get to the jury. On the issue of the other admissions, if you take all those admissions and you take them at face value, all she has admitted is she doesn't know how the hole was formed. She doesn't have to. She doesn't know when it was formed. She doesn't have to. And she doesn't know that they ever had actual notice of it. She doesn't have to. Honestly, their statement of undisputed material facts does not adequately state that she did not, that TSCPA could not have received notice if they had performed, sorry, I wrote this down better than I'm saying it, that reasonable diligence, no admission was requested that there was no evidence that it was long enough to find it with reasonable diligence. None of their admissions, or none of their statements of undisputed material facts say that they couldn't have found the hole, or that they shouldn't have found the hole, or that a regular inspection would not have found the hole. It just says, you don't know when it got there, you don't know how it got there.
Do regular inspections of property normally include searching your lawn for depressions?
So, I would submit that a regular inspection of your property would mean, again, you don't go through with a fine-tooth comb. You know, if we're talking about a small 2-inch hole, we're talking about something different. But it would involve seeing what's there to be seen. And you will see again when you look at the picture, this is an obvious hole right off the sidewalk of the ingress to their property. A regular inspection would see that hole. It's not hiding. The other thing I would
But no proof in the record as to when that depression developed.
There's not, and they don't have to have it. They just need to know that it was there long enough that a reasonable inspection could have found it. And here, we submit that at least to get to the jury. Whether the jury has to agree with us or not, that's up to the jury. But there's enough to get to the jury. And the trial court didn't get there, and the reason the trial court didn't get there was it made two findings that are incorrect. One is it held that she admitted there was no constructive notice. She never did. And the second is, and she even told the judge flat out at the hearing, and the court noted it in its footnote. She's saying this is only actual notice is all she admitted. And the court ignored that and repeatedly said, but she said there's no notice. The other thing is the court refused to consider the evidence solely based on a technical noncompliance with Rule 56.03. And as the cases cited in my brief say, you can excuse that technical noncompliance, and this court has even on occasion overturned a trial court for granting summary judgment based on that technical noncompliance.
Counsel, would you agree that the expert report would not have provided any evidence to the trial court as to how long the hole had been there? It says there's a duty to inspect, but that the expert report would not have indicated to the trial court any evidentiary basis for how long the actual hole had existed?
Mostly correct, except where it does have a description of what it saw about the hole, the size of the hole, the fact that the grass had grown over it. But other than that, no. And all of that can be seen with the photograph, which was also submitted and ignored by the court. Thank you, Your Honor.
Thank you. Thanks to both of you. Would you call the next case, please?
James L. Davison,